Guardian ad litem, often referred to as a GAL, is a child advocate. They are actually licensed attorneys that represent the best interest of children. They don't represent the children, they're not the child's lawyer, but rather they represent what is in the best interest of the court, and they advocate for that in court. Because they're a lawyer, they can't present evidence themselves via testimony or reports, but rather, just like any other lawyer in the case, they have to present evidence to the court through exhibits and witness testimony. A GAL would evaluate a case and prepare their case just like any other attorney. The unique piece is that they do get, to talk to children and then form their, recommendations about what a child wants or what's best for a child in a manner that is a bit more persuasive to the court. If you could think of them as sort of the first among equals, all, mom's attorney, dad's attorney, and then the best interest attorney are all equals insofar as they're attorneys, but courts tend to give them, the benefit of the doubt, maybe a little more credibility in presenting their findings because they're neutral. They don't represent mom's interest or, have any axe to grind against dad and vice versa. So the court tends to defer to them and the positions that they take relative to children's best interests. Their recommendations can actually be critical. And in fact, if a guardian ad litem gets involved in your case, it's extremely important that your attorney is communicating with that guardian ad litem. I've even known attorneys to really sort of make it a goal to co-opt or get the guardian ad litem on their side. So the guardian ad litem, just like another attorney, is an attorney that needs to be persuaded. And that happens with attorneys all the time. Part of why attorneys present their case is they want to convince the other side that if we were to go to court, I would prevail. Like, I'm presenting my case, I'm going to win, you're going to lose. That's what makes the other side become more willing to settle. And the same is true with the guardian ad litem, that if we're presenting evidence that persuades the guardian ad litem, that put together with the information that they gain talking to, the children, school officials, therapists, what have you, they're persuaded to essentially align with one parent's position or the other. It's going to be a boon for the parent the guardian ad litem sides with. So guardian ad litems are almost always in neglect and dependency cases, which are cases that are brought by the state when they found that, a parent or both parents are neglecting their children. So a guardian ad litem will be appointed on the behalf of the children's best interest in those cases. It's much rarer in a domestic relations case, a custody case, a divorce case, to have an appointed guardian ad litem. However, judges will often do that when they're a little concerned that the parents are too positional and maybe their viewpoints are, I would say, clouded, by their positions to be able to effectively represent their children's best interest. So the judge will say, hey, look, I want to make sure that I get a clear picture on what's best for these kids. In walks the guardian ad litem. Attorneys also can suggest to the court that a guardian ad litem would be appropriate, and sometimes they do that for the reason, I discussed earlier. They want to have someone who carries a bit more weight in the case siding with them and their position. And so that's generally the two ways that a guardian ad litem comes to be appointed in a domestic relations case. Guardian ad litems are attorneys that advocate on the behalf of children's best interest. If you need to have a guardian ad litem in your case, then you just need to understand that that's someone whose positions are probably going to carry more weight. If it's suggested to you that a guardian ad litem be appointed, you have to understand that, you're adding a third attorney into the mix whose opinions are probably going to take the day.